Tamamdır herhalde, değil mi? Dear guests, dear participants, hello and welcome to our webinar. I welcome you in my role as chair of the legal working group of TÜSİAD. Our event today is on international arbitration. We felt the need for this event because international arbitration is particularly important for an effective resolution of commercial disputes, which we are observing is on the rise, largely due to the pandemic and the measures that it's entailed, measures that the governments have had to adopt, as well as the financial turbulence that it's brought around the world. We have with us today Professor Dr. Ziya Akıncı. He is the chairman of the Istanbul Arbitration Center. We're very lucky to have with us Dr. Alice Fremuth-Wolf. She is the Secretary General of Vienna Arbitral Center. Again, we're very lucky to have Dr. Danya Fas. She is the Middle East Regional Director for Business Development of Arbitration and ADR of International Chamber of Commerce. Together with our guests is Ceyda Akbal-Schwiman. She is the Disputes Resolution Partner at ACO Law Firm, and she's the one who identified the need for this webinar and helped put it together and sponsored the idea. So we will kickstart with Professor Akıncı sharing with us the latest developments in relation to the Istanbul Arbitration Center. Following this introduction, Dr. Danya Fas and Dr. Alice Fremuth-Wolf will give us insight on how institutional arbitration works. Our moderator, Ceyda Akbal-Schwiman, will forward to our guests the most frequently encountered questions and issues on institutional rules of arbitration and the conduct of arbitration proceedings. We welcome from all participants questions at the end of the session for all of our guests. And we very much hope that you all find this webinar helpful for your practices and your businesses. Thank you. Ziya Bey, on to you, I guess, or Ceyda maybe.
Professor Akıncı, please, I think he will start.
Thank you very much. Thank you very much. Well, special thanks to TÜSİAD and especially to Meltem Hanım and Ceyda Hanım for this kind invitation. I'm very happy and proud to be with you today. And also I'm very proud to be together in this panel with two distinguished colleagues of mine from two distinguished institutes, ICC and VIAG. ICC is the leading institute, and I am also very proud of acting as a court member for 9 years. So it has been an excellent experience. And I had some of my cases in Vienna, and it is an excellent place to arbitrate for many reasons. So I think we have all two very distinguished and interesting colleagues. I'm also looking forward to hearing from them. But today I'm going to talk about Istanbul Arbitration Center. I'm going to give an introduction and some update information. Istanbul Arbitration Center is a relatively new institute, but it is a growing center. It has been set up as a part of Istanbul Finance Center. And ISTAC rules, on the other hand, is a very familiar if you are familiar with arbitration. So there is no surprise if you had arbitration with any other institutes. The rules are very similar for the international practitioners. For Turkish practitioners, Istanbul Arbitration Center offer more economic resolution for you, because especially for the medium size and big size cases in Turkey especially, the court's percentage fee is very high, and therefore Istanbul Arbitration Center offers a reasonable solution to the Turkish practitioners comparing to court fees. And for the international cases, Istanbul Arbitration Center became even cheaper after these exchange rates. You know, everything is much cheaper in Turkey, unfortunately, because of the currency issue in Turkey. But let's see the bright side. At least there is an opportunity to resolve your dispute with a reasonable budget. Istanbul Arbitration Center offers a reasonably fast solution, and the time for arbitration case is 6 months, and for fast track arbitration is 3 months. And I'm very proud of saying that for the domestic cases, especially, we reached this goal. I mean, 3 months may be very challenging, but all our fast-track arbitration cases has been completed within 3 months, and most of our domestic cases has been completed within 6 months as well. But for international cases, for big, giant construction cases or M&A cases, of course, like in other arbitration institute, the time may be a little bit longer, but still it is much, much shorter in arbitration comparing to national courts, especially the courts in Turkey. When we look at our figures, 15% of our cases, 15% of our cases are international, which is not bad for Turkey. And as you can imagine, most of our cases involved European countries, but recently we had cases from Singapore, Hong Kong, Pakistan, and Middle Eastern countries. So this means that Istanbul Arbitration Center is being considered for the international dispute resolution for different kind of projects. When we analyze our cases, most of our disputes arise from sale contract and construction contract. I think this is quite usual in many arbitration institute. We had some number of energy disputes, especially recently. Corporate disputes are also one of our most common, most frequently disputes. And recently we had more and more IT disputes. I find it personally quite interesting, but there are really very interesting topics and disputes to resolve. That is, I think, the development. For international cases, especially in Istanbul Arbitration Center, we have a international board. And if you are familiar with arbitration, the board members of our international board is a very famous, well-known colleagues such as Professor Jan Poulsen, Professor Bernard Hanosio, Dr. Hamid Karavi, and the majority of the board are foreign. So the international board of ISTAC is really international. So that means you can choose arbitrators, foreign arbitrators, you can choose foreign attorneys if you like, you can choose language of arbitration, and of course you can choose applicable law and seat of arbitration. And these days anyway, we are having online arbitration. Since the pandemic, we had guidance for online arbitration. So therefore, most of our cases are being conducted online without physical hearings. But having said this, we have facilities in Istanbul Arbitration Center that we offer these facilities to our users free of charge. And also we try to utilize technology like artificial intelligence and virtual reality. So we are a new institute, but we are trying to make it up. And this concludes my introduction, and I would like to wish you a very enjoyable and successful conference. Thank you for your attention.
Thank you very much for this kind introduction. It's very good and very encouraging to hear this good news about our National Arbitration Center. But when we come to practice, we often hear from especially international investors also the possibility to choose international arbitral centers. That's why we are going to hear from them how arbitration practice works with them, especially in these days of pandemic. Therefore, we have prepared some questions, and we would like to thank Professor Akıncı for this very kind introduction. Thank you very much. We have prepared some questions on the conduct of arbitration proceedings. to our two distinguished guests, Dr. Daniel Fast and Dr. Premut Wolf, on the most frequently asked questions when we want to file arbitration proceedings, the questions that we often get from parties or even sometimes from prospective arbitrators. We have listed them and we are going to discuss them in the forms of questions and answers with our two distinguished guests. So I would like to start, before we start these questions, I would like to ask our two guests, maybe with Tanya, Dr. Fast first, about the cases that you have been handling in 2021, after the pandemic has started, and I assume this year the cases have accumulated. What has been the developments for ICC? What kind of cases were most common? And I would like to ask then the same question to Viak. What kind of disputes you have been most busy? So
thank you, Seida. And first, I would like to thank TÜSİAD for this invitation to be part of this webinar. I'm privileged and I'm very pleased to be sharing this panel with such esteemed and distinguished guests such as Dr. Wolf and Dr. Akinci. First, let me please try to maybe give you some idea around some statistics that we have in the MENA region in general, and particularly with respect to Turkey. If someone can share the slides from the IT.
I think you are able to share.
Okay, I'll do it. Are you able to see my slides?
Fortunately, no. Oh yeah, now it works. Yes.
Yes. Okay. So just to give you an idea around the geographic origin of parties that we see in the MENA region, it's worth noting that the number of parties involved in ICC arbitration in the MENA region has been on the rise, and within the last 10 years, this number actually has more than tripled. And according to the latest ICC statistics, the UAE, Qatar, Saudi Arabia, and Turkey were consistently among the 20 most frequently listed nationalities worldwide.
Mm-hmm.
If just to give you some idea, if you look at 2018, for example, Turkey was ranked 10th. So it was one of the first 10 first ranked countries where the parties originated in disputes coming from the MENA region. In 2019, it regressed a little bit and it was ranked at 16th after UAE and Saudi Arabia. And in 2020, actually, it went upward again, and Turkey is listed as on the 12th position. The number of parties from the Middle East has increased around 17%, and today we have 296 compared to the previous year where we had 256.
Mm-hmm.
And this is just to give you an idea and to put this in a global context. We see that Turkey was ranked 10th in 2018 and was among the first 10 nationalities represented in disputes governed by the ICC rules. In 2019 and 2020, it was outed from the charts. However, Turkey still is at a very decent position. As I mentioned, in 2019, it was ranked 16, and in 2020, it was ranked 13. In terms of industries featured in the MENA cases, we see, unsurprisingly, the predominance of the construction field arising from the traditional types of disputes related to building and design services, support, security and construction services, design of pipeline equipment, etc. Now, unsurprisingly, the pandemic has impacted the types of disputes that actually may have arisen. And due to the cash flow shortage and the disruption that we have witnessed across this value chain, and that actually has hit all stakeholders across the value chain, we've seen claims related mainly to outstanding fees, contractual payment default, repudiatory termination for contract, call-on guarantee, and delay in completion. These are the particular disputes that have arisen under the pandemic. if we look at the main sectors represented globally, we see actually that the distribution in the MENA region mirrors the distribution that we see globally. So the main champion sectors, if I may so, remain the construction and engineering, energy, followed by transportation. So this is in a nutshell, just to answer your introductory questions, Sheyda, regarding what types of disputes have we been encountering since the eruption of the pandemic, and what were the main sectors that we see in the MENA region, and Turkey obviously being part of this region. I think what I was just mentioning is quite relevant to Turkey.
Thank you very much.
I will stop sharing now.
Yes, thank you. Alice, could we hear your experience?
Yes, thank you very much. Also, first, let me start by saying thank you very much, Seda, for organizing this webinar, for TÜSİAD, for hosting us. And it's a real pleasure for me to be sitting on this learned panel. And in order to really show this sort of collaboration that various arbitral institutions, especially also in the wake of the pandemic, have shown. And I think it's great that we can share experiences, that we can compare rules. So in order to provide to the user the best possible choice, because not each case is suitable for each and any institution. And I think this informed choice is really so important. So I hope to be able to contribute today to this task a little bit. Jada, if I may, I could also share my screen, because I've opened the statistics webpage on our website, and I can just lead you through it.
Yes, please.
So, yep. Can you all see the statistics? Seda, is it visible?
Yes, we see it.
Okay, excellent. So I can pretty much echo what has been just explained before in terms of numbers of parties and so on. The statistics are as follows. I mean, last year we really had, unlike other institutions, we had a decline in cases. And this year we had a real rise in cases, and the reason being that last year in our region where VIOC operates, which is mainly the CEE area and also stretching to the CIS, a lot of governments had put in place legislations where time limits were halted, where payments were stalled. So I mean, people were just holding their breath. But this year, all these cases were sort of accumulating, and it's basically in terms of the types of cases, it's pretty much the same as Dana described before: late payments, non-fulfillment of contracts, and so on. Our main share of sort of cases is commercial contracts and business relationship. That are the statistics from last year. I have looked at the numbers for this year. I see a little bit more construction cases coming, but again, you know, due to impossibility of to obtain goods in order to complete certain contracts, this is what we are seeing this year. In terms of parties, sadly, we only had one Turkish party last year, which I hope will change in the future. And yes, our rules are available in Turkish language. We're just working also on an adaptation for the 2021 revision, and there will also be a translation of our investment arbitration rules that entered into force 1st of July 2021 into Turkish language. So that is our contribution in order to make it easier also for foreign parties to be able to read the rules in their respective language.
That's great.
That's it from me for this introductory bit.
Thank
I will
you.
stop sharing the slides if I can.
Okay, then maybe we can start with our questions on how arbitration works in practice from an institutional perspective, especially in times when we have to conduct business mostly virtually. I would like to ask Alice first. In today's world, you know, most of us, we work from home. How do we file arbitration proceedings with VIOC? Is it sufficient to send emails, or do we still need to ship you hard copies? Do you still serve notice of the hard copies to the parties? I would like to hear how this works with BIAC and then how it works with ICC recently, whether you have changed your practices or established practices and to which extent.
Yes, thank you very much. I think that's it's a really good question, very practically relevant. And we have deliberated a lot about this also in the wake of the Rules Revision 2021. To initiate arbitration proceedings, it's sufficient that we receive the statement of claim in an electronic version. But, and that's the caveat for the commercial disputes, we also ask the claimant to submit a hard copy. Not like 5 copies for each arbitrator, but just 1 copy or the number of copies in the number of respondents. So if you have 1 respondent, we need 1 copy. If you have 2 respondents, 2. And you could ask, why do you need that? We have arrived in the digital area and all that, and it's true, but we have made the experience that it's so key to send a hard copy version to the respondent by DHL, by postal service, to have a real return receipt, because it happens quite often that the respondent does not participate in the proceedings, and it's crucial for the claimant to have some sort of proof that actually the respondent was duly notified of the statement of claim. And we have not found any better solution than, the return received by postal services. We have also, but apart from that, that's the only point until again, when we deliver the award, where we can conduct completely paperlessly the arbitration. We have instituted also the VIAC portal, which is a file sharing platform. The parties are then invited to sign on, and the rest of the proceedings is all conducted via this portal and sort of paperlessly. But for this very initiation, we have come to the conclusion it's in the best interest of all parties if we still insist on sending the paper.
Okay. Danya, is it different at ICC or?
I would say it's similar to a certain extent, but let me step back and go back to the times when the pandemic erupted at first. And just to let you know that the Secretariat at the ICC, well before the COVID-19, was communicating with parties by electronic means, by emails. So communication has always been occurring by emails, electronic means. Now, what happened during the pandemic, when the pandemic erupted, with all the disruptions in the courier services, because the previous practice was to have the electronic submissions together with the hard copies. When we faced problems with the courier delivery and shipments were completely disrupted, we expressly, the ICC Secretariat, asked the parties to file electronically, to submit electronically their requests. And what was done that after receiving the submission electronically, the Secretariat would liaise with the other party to see to what extent electronic notification would be feasible. And I can say that actually this has happened quite smoothly. And the submissions were not disrupted during not in the aftermath, because we're still in the pandemic, unfortunately, but since the eruption of the pandemic, and even a couple of weeks into the pandemic, we were actually business as usual at ICC in this respect. Now, clear communication with the parties as early as March 2020 to make it clear that expressly they can submit electronically. Some were a bit reluctant to submit electronically, some users in the region, but we made sure to them that submitting electronically was as safe and as secure as submitting hard copies. And these issues were addressed very early on, and it went quite smoothly. Okay. And later on, to streamline the process, the ICC issued a guidance note on the 9th of April 2020, so again, early on. And in this guidance note, it provided the parties and the arbitral tribunal with some guidelines on how to streamline these processes and mainly how to organize virtual hearings. And I think we'll be touching on that later on during the webinar, because holding virtual hearings was also another challenge that we had to face beyond the submissions of the requests.
We'll come to that. But thank you very much for these explanations. I will again go with the chronological order of filing a proceeding. Very often we see in arbitration agreements that the venue of the arbitration, the place of arbitration is agreed. Sometimes it's not agreed. I want to ask first, Danya, how do you fix the place of arbitration if it's not in the contract, in the arbitration agreement is ICC?
Yeah. Well, as you know, arbitration is a consensual process at the outset. So we expect that the place of arbitration be agreed on by the parties. But as you correctly mentioned, Seda, in many instances, the dispute resolution clause would not provide for the place of arbitration. Understanding the place of arbitration as the seat of arbitration, because here we need also to draw a distinction between the legal seat of arbitration and the location where the hearings can be held and where the parties can convene. And these are not the same at all. The legal seat of arbitration entails legal consequences, and it is actually the legal domicile of the award. So it will entail consequences in terms of the procedural law of the seat that will govern the arbitration proceedings. Another main consequence is that the courts of the seat of arbitration will be playing a role in supervising the arbitration proceedings. Now, when the parties do not agree on the seat of arbitration, the court, the ICC court, will fix the seat of arbitration depending on the circumstances of the case, having regards to the nationality of the parties, to maybe where the obligations, contractual obligations were delivered, the place of signature of the contract, and other procedural issues such as the language of arbitration is a relevant element because it will help us save on costs later on and avoid some translation related costs. So all these elements are taken into account when fixing the seat of arbitration. As I mentioned, it is the legal seat of arbitration. Now, when it comes to the location where the parties and the arbitral tribunal might hold their hearings, this is a question of logistics. And this question can be determined by the arbitral tribunal after consulting with the parties, taking into consideration convenience, logistical issues, where it would be best to meet, what it would be less costly maybe to meet. And this is also monitored by the Secretariat, meaning that if, for instance, the arbitral tribunal or one of the arbitrators might suggest a place that maybe might be very costly and might entail unjustified costs, the Secretariat might also intervene here and actually communicate with the arbitrator to understand better why this location is being suggested as a venue for holding the hearings. So this is in a nutshell how we manage the place of arbitration and determining the seat, legal seat of arbitration.
At least I think the rules are a bit different under Vienna rules, isn't it?
Yes, we really have the comfortable sort of situation when the parties have not agreed either on purpose or because they forget. We have a fallback provision in the rules stating that then it's automatically Vienna. And again, in the 2021 rules revision for the commercial rules, we have sort of reconsidered it, and we came to the conclusion that for commercial arbitration, we still feel safe to keep it. We have had a surveys with our users and they said, no, please leave it. At least we know where we will end up in a robust legal system when we can't agree. And very often, you know, it's quite a deliberation. And the courts in Austria are very arbitration friendly, very supportive. We have the Supreme Court as first and only instance for setting aside proceedings. So that's why we felt to keep it. But for investment arbitration, this is another animal. And here this fallback provision does not exist. And here probably the court, the board will have to then determine according to the criteria that have just been described, what is the best place for this particular circumstances. Again, not confusing seat with the place of the hearing, because that's different. Another.
That's what I want to come to. Actually, Danya told us a little bit about the difference of the seat of the arbitration and where actually arbitration takes place. You know, sometimes we get the question if we have an arbitration seated in London, especially in the pandemic situation, do we really have to go to London, you know, for our arbitrations? How does it work with the virtual hearings, virtual meetings, you know, conferences? I would like to hear a little bit first, maybe via experience, than from Danya, ICC's experience. I think this is really crucial in today's proceedings with the travel restrictions. It's a very important question. So I guess, can you tell us a little bit how has been your experience with virtual arbitration?
Yeah, with pleasure. Well, first of all, just as an anecdote, I mean, it usually happens with us that people don't say, do we have to go to Vienna, but rather the reverse. Can we come to Vienna to have the hearing here? And, you know, the Austrian Federal Economic Chamber, where we are located, has really cool premises at a very favorable rate. And a lot of parties and arbitrators before the pandemic have made use of it. And even in between, when the pandemic was, you know, at the low, or in order to conduct sort of semi-virtual hearings, all that hearing facilities are equipped with the necessary equipment and can be booked by the parties and arbitrators. But yes, all of a sudden we were also faced with the situation that hearings had to be changed. And here again, I think we were fortunate that our arbitrators were quite brave, again, with VIAC being at the side and assisting the arbitrators. And especially those cases were crucial or were difficult, where one of the parties took this as an opportunity to obstruct the proceedings. And we had this very famous case that went through the media last year in summer, where the Austrian Supreme Court had to decide that it was a VIAC case where the arbitral tribunal decided to hold the hearing remote, despite one of the parties being in disagreement with it, and thereafter was challenged by that party of being not impartial and independent. The VIAC board was the first instance, did not give leave because the arbitrator had very well reasoned that decision. And then the party went directly to the Supreme Court, which is the case, or which is possible. And here, this sort of landmark decision was rendered by the Supreme Court within 3 months, and we had it in July, where the Supreme Court really laid down what are the criteria if a remote hearing sort of really infringes rights of the parties. So it's not the automatic sort of result that if one of the parties is in disagreement, this already means the tribunal is not impartial and independent, and that does also not mean that the award can be set aside. But he set thresholds and said, well, fair and equal treatment of the parties and the right to be heard has to be observed. And there, in each and every case, there are nuances where the arbitral tribunal has to weigh. And after that decision, we also issued sort of the VIAC protocol that is really a guideline for the arbitrators and parties, like a checklist. What do they have to observe when taking the decision whether to conduct the hearing remotely? But so far, most of the hearings went quite smoothly on that remote setting.
Okay, thank you. Dania, how is it with ICC? Although I have to say, before pandemic, I made the experience of having virtual hearings under ICC rules, and it went quite smoothly. But how did it work after ICC, after the pandemic has started?
Yes, Seda, absolutely. I mean, virtual hearings have taken place before the COVID-19 pandemic, but it is also true to say that it was not the mainstream at all. It was not the mainstream, and parties and arbitral tribunals had a preference for holding physical hearings. Now, the situation changed with the pandemic for the simple reason that holding physical hearings was not an option in many instances and in many countries. Due to the restrictions, travel restrictions, and so on, we are all familiar with by now. And the parties and the arbitral tribunal were left with the option either to postpone to a non-determined date the hearings, which is not quite efficient for the conducting of the proceedings, or to decide to proceed with virtual hearings. Now, the situation is quite straightforward when both parties agree after consultation with the tribunal to proceed with virtual hearings. Another situation is the one that you mentioned, Seda, when one of the parties might object to holding virtual hearings. And the question that has arisen is to know whether the arbitrator can proceed with virtual hearings over the objection of any of the parties. And the response actually is, it is possible. It is possible for different reasons. First, it is in the duty of the arbitrator under the ICC rules to make sure that the proceedings are conducted in an expeditious manner. And this is a power that is recognized to the arbitration. It goes under its broad procedural authority. Now, careful consideration should be given when making such a decision to two main things. First is to provide the reasons for that determination. And within providing the reasons, the arbitrator should highlight that the parties would be given the equal opportunity to present their case and the due process would be respected. So the arbitral tribunal may invite the party objecting to explain why this party is objecting to holding virtual hearings. In the absence of valid reasons or valid justification, the arbitrator can overcome such an objection, provided, as I mentioned, to provide the reasons for that, to make sure that due process is being respected, and also to have regards to the procedural law of the seat to make sure that the award would be enforceable down the line. So these are the two main safeguards that should be kept in mind. And again, as I mentioned, it rests with the arbitrator to make sure that the proceedings are conducted in an expeditious manner. It is also actually a shared duty with the parties under the ICC rules to make sure that the proceedings are conducted in an efficient, cost-efficient and time-efficient manner.
Yes, you are right. I mean, it's really crucial that the seat of the arbitration should allow for virtual hearings. Otherwise,
And I should mention maybe that under the ICC rules, before the latest amendments entered into in January 2021, the very recent amendments, and there has been some ambiguity regarding the language of Article 25.2, stating that the tribunal shall hear the parties together in person if any of them so request. And the language of in person was construed by the court and the Secretariat as referring to the parties being given the opportunity to have a live and adversarial exchange, and not necessarily to have an in-person physical hearings. It can be an in-person by virtual means. And with the new amendments that entered into force in January 2021, this ambiguity has been lifted as the language has been completely removed in line with this construction.
Okay. So we don't have any issues with holding virtual hearings.
No, provided the safeguards are well respected.
And the seat of the arbitration allows virtual hearings.
Yes, and the parties are given equal opportunities. And another element here that also comes up in practice, SEDA, is that the arbitrator or the tribunal should make sure that both counsels, both parties have the same technological means to conduct these hearings. And you need to have equal means. Otherwise, due process would not be would be breached.
Of course. Yeah. Great. Then let's say I have I'm about to file my proceeding, or I have filed it, but I need a measure in injunctive relief urgently to prevent that my rights are breached. Is there any possibility under arbitration rules that as a claimant I can make use of? This question comes very often to us. And I would like to ask this question to Danya first under ICC rules, because I know from practice that under ICC rules, this comes up quite often. Is there, if I want to file a proceeding, or let's say I have filed that I cannot wait until the tribunal is constituted, which takes some time. Is there a way to get an injunctive relief from ICC?
Yes. Shayda, the line was breaking a little bit, but if I understood correctly, you're asking about when the parties have agreed to an arbitration agreement, but before the claimant, before filing the request, he is interested in receiving an interim or conservatory measure.
Or before the tribunal is constituted.
Constituted, yes. Well, one procedure that is available to the claimant is the emergency arbitrated procedure. And this procedure is actually today widely accepted by several arbitral institutions, not only the ICC. It was introduced by the ICC early on in 2012. And since then, we have seen actually an increase in the submissions of requests for emergency arbitrator. Now, the aim of this of introducing these rules was to fill a gap where the parties needed, the claimant mainly, would have needed an interim relief, before the constitution of the arbitral tribunal. And the granting of such relief could not await the constitution of the arbitral tribunal. The option that was available and that is still available, as most of the jurisdictions do recognize the concurrent jurisdiction between state courts and the arbitral tribunal, was to go to state courts. However, arbitral institutions found that it would be very relevant and maybe very sensible to give the option to have a recourse to an arbitrator for granting the interim relief and the conservatory measure. And these provisions, as I mentioned, were introduced in 2012 in the ICC rules. In terms of scope of application, the provisions would apply to any arbitration agreement concluded on or after January 2012, 1st of January 2012. It will apply only to the parties, obviously, that have signed the arbitration agreement, and unless the parties have opted out of this procedure. If the parties have not opted out, it will apply by default, meaning having a dispute resolution clause under the ICC rules in the agreement would be sufficient and would entitle the claimant to benefit from this procedure. The emergency arbitrator provisions would not apply if the arbitration agreement arises from a treaty. This is just to factor this exceptional situation. Now, the ICC has issued its report back in 2018, the Icc Commission on Arbitration and Adr. This is a task force report that has analyzed all 80 cases that were submitted to the ICC until 2018, from 2012 to 2018. And it's a thorough and comprehensive analysis that is available on the website. And I really advise everyone interested in learning more about this procedure to consult the report on the website. The main observations that can be drawn from this report is that there is no universal approach when it comes to threshold issues, whether procedural or substantive issues. So there is a great degree of flexibility given to the emergency arbitrator in that respect. And the analysis of the cases revealed that the emergency arbitrator was applying a strict requirement that the relief being sought cannot await the constitution of the arbitral tribunal. And the third observation that can be made is that it is only in a minority of cases that the relief was granted. And this doesn't come as a surprise, as we all know that in essence, interim relief is an exception, is by nature an exceptional relief. Now, I'm not sure if we have time to dwell more on that, but I can share some statistics with you to show you, I mean, the positive trend in such applications for emergency arbitrator.
I think very shortly, it's really, I know that this is an interesting question for Turkish parties, so I think it would be quite useful if you briefly can inform us.
Yes, so just to let you know, to this day, we have had 154 applications since the introduction of the emergency arbitrator. We started at low figures in 2013. To give you an example, we had only 6. 2015, we've been seeing the upward trend, having 10 applications. As of 2016, we've been having around 25 in average. And in 2020, we have 32 applications for emergency arbitrator. So we see definitely a positive trend here.
And do you know how many of them were granted?
Yes, we have around 125 orders, even more, a little bit more now if we take 2020. And they were also granted within a time limit of 15 days by the emergency arbitrator.
And do parties comply with those orders individually, voluntarily? Because
yes,
that's the difference to a court injunctive order. So it would be good to know your experience, whether they
Saida, you're touching on here on the sensitive point here of the emergency arbitrator order or decision being the enforceability. And it is true that in practice, we see a majority of cases where we see a voluntary compliance, which addresses indirectly the issue of enforceability, because the parties are willing to comply in order to avoid starting the arbitration on, if I may say, on a bad foot, you know, even if the order is not seen as a binding one or as maybe enforceable as an award. However, we do see a voluntary compliance in practice, a high rate of voluntary compliance.
Okay, great, thank you. Alice, I know IACTs are a little bit different. Could you tell us a little bit about this?
Yes, absolutely. I have listened carefully what has just been said, and has just confirmed sort of the view that we have, that emergency arbitrator provisions, we did not institute them even in the 2021 rules revision for various reasons. First of all, we consider them a very costly exercise. I mean, it's a one-off fee of, I think it's $40,000. And, you know, the cases that we are operating in the region that we have, sometimes they are about 100,000, 200,000 euros, which is a quite high amount for the parties. And if on top of that, just for an emergency arbitrator decision, they would have to pay this sort of amount of money for not even getting an enforceable decisions, because in our region, there is no state law provision giving the emergency arbitrator decision enforceable effect, meaning that the New York Convention is not applicable. So as long as this is not provided for, and of course we're monitoring the working group 2 UNCITRAL developments, and if the states came to the conclusion that such a provision would be instituted on a wider level to granting those decisions also enforceable effect, then we would reconsider. But I think if parties really need something enforceable, they can go to the state courts even before the arbitration has been started. We have made excellent sort of experience with the state courts in Austria and also in the region, who do not shy away to grant interim injunctions in support of arbitration proceedings. And you have the benefit that it's also immediately enforceable at that particular place. So that's why we considered for the parties where we do business and the region where we do business, there's no need. And as it always is the case, when you have a certain tool available, it's an invitation for the parties to use them. And I question whether all those cases where emergency arbitrator sort of decision is being requested is really necessary. And as we have heard before, also quite a lot of number of cases have not been granted. So why put the parties through this? And it's good for the parties to have this choice.
Yes, definitely. And it's up to the council to assess whether there are chances or not. Yeah. Okay.
Just to follow, if I may, just to follow up on what Alice was just sharing. And I agree actually with her point of view in practice. However, it's also worth mentioning that it is a case-by-case approach, because we at ICC most likely, and since 2012, had this sort of discussion and analysis on the suitability of this, bringing this tool and making it available to the parties. And the decision was made actually to make it available. However, as Alice was mentioning, it is a tool, and it would be subject to the strategic considerations of the parties. It's not a procedure that would be recommended in every case, not at all. It would be very much dependent on the type of relief that is being sought, what type of relief, on the circumstances, on the case specifics, and then it is up to the councils to make such a strategic assessment before filing a request for an interim relief or a conservatory measure. So it's really a case-by-case approach. For some cases, maybe going to state court would be more sensible. For other cases, it might be a very sensible tool made available to them before starting arbitration, resorting to an emergency arbitrator. And in many instances, it can help the parties to narrow down also their issues. And we've seen quite actually interesting cases where actually they ended up settling. So
yes, I will come later on. I think that's
yes, so it can help, although as we all know, it will not be a discussion on the merits. But in some instances, it can help to maybe narrow down and to clarify the positions of the parties.
Okay, then I will move to the next question. I would like to ask a little bit the function of the Secretariat, because very often we see in contracts parties agreeing on ad hoc arbitration. But we as council, we have made the experience that institutional arbitration institutions are worth the fees that they are paid. And so I want to take an example. For instance, is a claimant, I have filed a claim, the respondent doesn't react, doesn't appoint the arbitrator. How do you choose the arbitrator? And from this, can you tell us a little bit how Secretariat works and supports before the arbitrators are appointed, before the tribunal is constituted, and after the tribunal is constituted? I would like this question first to Dania under ICC rules, and then I would like to hear from Alice how the Secretariat at Alice, at VIAC, works according to her experience. So, Dania, can you tell us a little bit how does Secretariat work? How do you choose arbitrators? You know, what do you look at, and how do you support them afterwards?
Yeah. In terms of appointing the arbitrators, the Secretariat and the court actually play a role in confirming the arbitrators when they are suggested by the parties. And this is a majority of the cases, actually. As we know, again, arbitration is a consensual process, and it sits within the parties to propose their arbitrators, whether they're wings, or to agree on a sole arbitrator. Now, in some instances where the parties do not agree on a sole arbitrator, or fail maybe to propose an arbitrator within a time limit, because there is a time limit also to select an arbitrator for each party, then here the court and the Secretariat would step in to, again, enhance the efficiency of the process and avoid any obstruction, and appoint an arbitrator. Now, how does the court or the Secretariat proceed with this appointment? We normally go to the national courts in the jurisdictions where we would like to have an arbitrator national from this specific jurisdiction. And upon the suggestions of the National Committee, we select an arbitrator. We are not bound by the proposal of the NC. We take it into consideration, but this is one avenue. In some jurisdictions—
the National Committee of ICC, right? Yes.
Absolutely, yes. National Committee of ICC. Thank you for highlighting it, to say that. And in some jurisdictions where we don't have an NC, it would be a direct appointment. And many ask this very familiar question, whether the ICC has or has not a roster of arbitrators. We do not have a roster of official arbitrators. However, we have experienced many arbitrators in many cases, and we have tested many arbitrators, if I may say so. And we do sometimes think of an arbitrator if we don't have any name coming from an NC, or we don't have an NC in some jurisdiction, and we need a specific profile with a specific expertise, dwell in one national law, the language. All these elements are taken into consideration, and based on that, we can propose directly an appointment. Okay. Now, another situation where things can get complicated is after the appointment and the confirmation. I'm not sure if you want to discuss this now, Shayden, when there are challenges to the appointment, and how do we deal with these challenges?
It would be great if you can tell us a little bit, you know, how that works, and how you support the arbitrators or the council afterwards.
So parties can actually submit and make a written statement to challenge an arbitrator that was appointed or confirmed. Now, this should be done by written submission to the Secretariat, and detailing obviously the circumstances and all the terms and conditions that would give rise to have some sort of alleged lack of impartiality or independence on the part of the arbitrator. The arbitrator is given the opportunity to comment on the challenge being raised, and this challenge should be raised by the party within 30 days from the date they are notified with the decision of appointing or confirming the arbitrator, or within 30 days from the date when the party is made aware of the circumstances that has given rise to this challenge. Now, the court, the ICC court, will actually determine and will examine the challenge both on the admissibility level to see if it was submitted within the procedural time limit, and also on the merits. And either will accept the challenge or will reject it.
And after the tribunal is constituted, do you set back? Is the Secretariat, does it set back, or do they support the arbitrators or the council when they have there are issues? You know, just very briefly, if you can tell us.
It's a very what we try to do is a very fair process, and to have a very objective process in assessing these elements. It's really a case-by-case approach. The court will examine very diligently the reasons set out in the challenge. If these are frivolous reasons and non-serious reasons, the court will unconditionally support the arbitrator. If there are valid reasons, it will be an examination in depth. It will communicate with the arbitrator. It will understand better. Let's take an example where, for example, there was a failure of disclosure. And based on, after this exchange, the decision would be made either to accept the challenge if there are some valid reasons that can give rise to and can make the doubt over the impartiality or the independence of the arbitrator reasonable or not.
Okay. Alice, thank you very much, Tanya. Alice, is it different under VIAC rules? How does Secretariat at VIAC work in terms of appointing arbitrators or supporting arbitrators or counsel when there are issues?
Well, first of all, I can say that we always have had a very hands-on approach in the Secretariat. So we are really there for the parties, for the arbitrators, for the counsel, of course, bearing in mind that there should not be any ex parte communication, like really ex parte communication discussing the issue, but it's still absolutely okay for counsel or arbitrators to call up to ask a small question to details. And each and every case is being assigned to one case manager, and that case manager directly reports either to myself or to head of case management, which is my deputy. So whenever a difficult question arises in the course of arbitration, there's always immediate attention by head of case management and can really react. So even if the case is being transferred to the arbitration tribunal, we have a mirror file. We really try to sort of be on top of the case and really assist the parties and especially the arbitrators in difficult situations as we had seen during the pandemic. When it comes to the appointment of arbitrators, it's the task of the board. We have 15 board members, really diverse, not only in terms of nationality and region, but also gender and also in terms of profession. And we don't have any committees. It's always the whole board as a plenum who decides the best candidate for each and any appointment. And we have really made it also a point in terms of diversity, not only male and female, but also younger arbitrators to give them the chance of first appointments to really strike a very good balance on who is to be appointed. And the Secretariat, of course, assists in, pre-checking, providing sort of potential candidates, but it's always a fierce discussion within the board sessions or in circular vote where all the board members take part. So I think that's really good because you get the knowledge of all the board, not only of a couple of people who always tend to appoint the same people. And in order to make that also visible, we have on the website since many years also the name of all the arbitrators that have been appointed or nominated or sort of appointed or confirmed and acting under VIAC, in also to show the diversity that we employ. When it comes to challenges, I think it's a very similar procedure than as Tanya has described for the ICC. Again, it's the whole board as a plenum to decide on these matters, exactly taking into account what Tanya has said. And at the very end of the proceedings, when the award is being finalized by the arbitrators, it is sent to the Secretariat, and we don't have a full-fledged scrutiny as the ICC enshrined in the rules, but still every award is being read. We check the cost provisions. We check all the formalities so that the award doesn't suffer from an error that needs then to be corrected. But it's a very swift procedure, and usually upon submission of the award to the Secretariat, it only takes about a week until the award is then vacated and sent out to the parties by the Secretariat. And again, as I mentioned before, that's the only other instance where we sort of have paper as the prime sort of matter of sending the award in paper form, because we have seen from the parties from the region where we operate that they need a paper copy with a stamp, with the ribbon. We, as WIAG is part of the Austrian Federal Economic Chamber, which again is a public legal entity, we can use the Austrian eagle, the emblem, on the awards, and that really gives it a very official character. And we have not seen any sort of problems in terms of enforcement because the award didn't look official. And that's why we insist, unless the parties both opt out of it, that we send the award by hard copy, again, also in order to have the return receipt, which is needed by the party who wants to enforce it, to have the proof that the award was actually received by the party. So yeah, that's the approach that the WIAG has.
Regarding scrutiny of the award, I mean, that's really unique to ICC, the scrutiny of the award by the court. Dani, is there anything you would like to add on that? That yes, works in practice, maybe because it's something special for...
Yes, just to confirm your point, to say that it is a distinctive feature of ICC arbitration. I think it's one of the most important features of the ICC rules in terms that it shields the award completely when it comes to its enforceability. The scrutiny process is not just a scrutiny of formalistic requirements. It goes beyond that. It doesn't go on the merits or the decision made by the arbitrator or arbitral tribunal. It scrutinizes the award in terms of having a proper reasoning within the award, of having avoiding any infra or ultra petita situations, having also regards to where the award might be enforceable, in what jurisdiction, having regards to the law applicable in the seat, and all this examination contributes to, again, shielding the award. It's a quality control process, if I may say so, for the parties. When they receive the award, they receive a solid enforceable document. And this is actually one of the major features of the ICC arbitration. We have at the ICC court members from different jurisdictions, from different walks of life. Some of them are academics. When the Court of Arbitration holds a hearing or a session to undertake this scrutiny, we have members who are dwelt in the applicable laws, who have a proper and deep examination of the award. We have a report set out by the Secretariat, a very detailed report. So it's not a process that we take lightly. It's a very, very important process at the ICC.
Thank you for the clarifications. I would like to come to a question that very often comes to us, counsel, before filing an arbitration, and I think is very important for business people for an efficient outcome. It's about the role of arbitrators for settlement after the proceedings are filed, after when a matter comes, or when a matter is with ICC, when a request for arbitration is filed. How is your experience, at the Secretariat, or it goes to both institutions, actually all institutions? How is your experience with settlements after the claims are filed? What are the rates of settlement, if you have any statistics, or at which stage does it happen? Usually right after filing, or in the middle? after the parties have a sense of the issues and how, in which directions the proceedings can go, or no, don't they settle at all? I would like to hear that first from Alice. How does it work?
Yeah, thank you. I think also here again, we have seen sort of a move. Of course, always a proportion of cases has settled, and not always the parties would disclose why. But I have seen, especially this year, that more cases than usual have settled right after the statement of claim has been filed, because sometimes it's really needed, you know, that you make known to the other side that this is serious talking now, and not just, yes, we might sue you. And we have also seen an inclination of parties to really use settlement tools more often. And that's why a couple of years ago, we have as a second pillar to the arbitration rules, also the mediation rules that really are designed to interplay with each other, which does not mean that we want arbitrators to double head and act as mediators, but in order to enable for parties who start out with an arbitration and then they come to the conclusion there might be now an opportunity for a mediation window where we really want to have a third party neutral assisting us outside, and then ideally being able to settle and coming back to the arbitration and requesting an award of on agreed terms from the already established arbitral tribunal. We wanted to facilitate that because very often parties, they want something enforceable. And as long as the Singapore Convention has not been ratified by as many states as the New York Convention, an arbitral award in terms of enforceability is unmatched, especially when you're not operating on a domestic or on a European basis where you have other instruments. And our contribution to this was that we said, okay, we're not double charging the parties as institution. So you have a one-stop shop. You start out with one process, and if you need to employ the other one, the administrative fees will stay the same. And when we set arbitrator fees, and the parties, for example, have settled at the very beginning of the proceedings, when the arbitral tribunal was not even appointed, of course, then there are no fees for the arbitral tribunal. And after that, we have the following rules of thumb. When they settle at the very beginning, I mean, the arbitration tribunal has been appointed, has received the file, has gone through it, they will receive a third of the fees because they have done their work. If they settle around the oral hearing, they will receive 2/3. And if they settle sort of at the very end, sometimes it happens that, the award has already been written, has been withheld, and the parties, try to settle, and only if they can't, then the award is being rendered. Then, of course, the tribunal receives the complete share of the fees because they have done the complete part of the proceedings. And that's how we try to handle this settlement situations, also to incentivize the parties because they can save on certain fees if they are able to do that. Because in the long run, in times as these with the pandemic, I really think very often it's to the benefit of the parties if they can come to a conclusion early on, because maybe in a year's time, the business partner no longer exists.
Unfortunately, that's a risk always. How is it with ICC, Danya? How is it in your experience? And about the cost, especially, it's at a very early stage, do they only end up paying filing fee or,
I mean, in terms of cost, the approach is very similar actually to what Alice was sharing. It depends really at what stage the settlement occurs. If it's early on, obviously the provisional cost will be readjusted. If it comes down the line where maybe the arbitrator has already spent a lot of time on the case, then it will be readjusted, but within this proportion. So it really depends on a case by case. Now, as also Alice was mentioning, we have the same approach of inviting also the parties to settle. So the arbitrator can help them to narrow their positions if also the parties ask him or her to do so. However, we should be vigilant not to have the arbitrator double hatting. for the simple reason that in some jurisdiction, the applicable procedural law would not allow it and would jeopardize the award down the line in case the settlement fails to happen. So the role of the arbitrator is to be supportive for the parties if they would like to settle. We offer a range of alternative dispute resolution mechanisms at the Icc ADR Center. We offer also, for example, the expertise service determination for free during the arbitration proceedings. If the parties wish to have recourse to mediation, this is also very much possible. We don't advise the arbitrator to act also as a mediator, to double hat here. What would happen is to open a window for mediation for the parties. The arbitration proceedings would be stayed pending the mediation process. And should the parties fail to reach a settlement after the mediation, then can come back to the arbitration. In the positive scenario where they reach a settlement, they are also welcome to come back to the arbitrator, and it often happens they ask for the settlement to be recorded as a consent award in order to have it enforceable as an award. As Alice was mentioning, under the Singapore Convention, we don't have the same international regime of enforceability that is provided by the New York Convention. So to be able to benefit from the New York Convention, parties from this international regime of enforcement might have all interest in asking for their settlement to be recorded as a consent award. It's not all the cases. Sometimes the parties just settle and they want even to keep their settlement confidential. The claimant can withdraw the claim. So it's one scenario. We have different scenarios. It depends really on a case-by-case approach. It depends also on the terms of the settlement. If it's just a withdrawal of claim, then it's just a withdrawal of claim, and maybe there's no need to have anything recorded in a consent award.
Of course, the advantage of consent award is the enforcement in case one of the parties doesn't comply with the terms of the settlement.
Yes.
Yeah.
When the settlement gives rise to substantive obligations, parties might have all interest to have it recorded in a consent award.
Seda, can I just add one little thing, because what Danya has said with sort of that some jurisdictions, in some jurisdictions, especially the arbitrators, are very hesitant to even sort of facilitate or assist the parties because it's against their role. We were mindful of this, and we have decided in the 2021 rules revision to insert a para in Article 28, where we, with a very soft language, have stated that under the VIAG rules, it is okay from our perspective, like from the institutional rules perspective, if the arbitrators assist the parties, or in their endeavors to reach a settlement, in order to open the door, but of course not stating you switch hats, but in order to give comfort to those arbitrators with this very strict background to say, okay, if I really see that they're very close, it's okay with my role under the VIAG rules to just give this little last sort of nudge to the parties that they need, but of course not switching roles. And we have also included this in the investment arbitration rules, because here we have seen from the discussion in the working group 3 that also states become more and more interested also to, being able to settle. Of course, you have different scenarios there, but also in order to incentivize this, as we really consider it in some cases to be the better option.
Yeah, I mean, I have to say, in the hands of experienced arbitrators, they know how to change hats, to encourage settlements while at the same time conducting proceedings, and it's usually not a problem, but it needs to be very carefully handled. But if you have experienced arbitrators, usually it works quite well. Okay, I think we have some questions here, and I think one of them relates to the topic directly. I would like to present it to Danya. It's about the duration of arbitration proceedings. Professor Akıncı mentioned that under ISTAC rules, the proceedings are very efficient, and it has been so, and it's extremely helpful to come to an efficient outcome and for the businesses to work in our experience in Turkey, is there a similar procedure? I mean, how is your experience? Is it really possible to come to an outcome within a period of 6 months, maybe under ICC rules, maybe under VIAC rules? Do the rules allow that? This is a question that is raised, especially under ICC rules. That's why I'm asking directly to Dania first, and then maybe we can share, compare experiences a little bit.
Yes, and I understand that this question also was raised for the ICC, being most seen as an institution heavily involved in very complex cases and very lengthy proceedings. However, with this concern in mind, the ICC has introduced the expedited procedure, the EPP. The expedited procedure provisions were introduced to cater for the cases that are not that complex and that can be resolved within 6 months. And there is actually a duty on the arbitrator to have the case settled within, resolved within 6 months. The aim is to cater for the claims that do not exceed 2 million USD until the latest amendment that was introduced in January, when the threshold, the upper threshold, was raised to 3 million today. So these proceedings are simplified proceedings. One sole arbitrator would be sitting. The fees of the arbitrators are reviewed, so are reduced. The arbitrator is empowered to, with procedural tools, to simplify the procedure. The arbitrator can determine and rule just on the document submission, and can require only to have submission of documents without having witness testimonies or having expertise required. So there is a margin and a big flexibility for the arbitrator to conduct these proceedings in a simplified manner and to have an award issued within 6 months. Now, as I mentioned, the threshold was reviewed from 2 million USD to 3 million. This is to take stock actually of the popularity of this procedure. That I should also note is based on an opt-in and opt-out, and many parties have opted in for this procedure, even for amounts beyond the threshold provided for by the rules. We've seen cases of 8 million, 10 million USD opting in for the EPP. Again, the value is not always an indicator for the complexity. So it can be beyond 2 million or 3 million and be a case that can be resolved efficiently while respecting, obviously, the integrity of the proceedings and the due process within 6 months. So efficiency is really now it sits high on the agenda of the ICC and of many arbitral institutions, especially in these days where the users and the clients are very, very, very mindful of the cost and the time spent on arbitration proceedings.
Thank you. But I think below 3 million, it's mandatory to apply expedited rules currently, yes, right? Yes. If the parties want to have 3 arbitrators,
yes,
it ends up with 1 arbitrator.
It will apply
below 3 million.
Absolutely, Sheda. Within the threshold, it will apply by operation of the rules, unless the parties opt out, but they need to opt out expressly for this threshold. Just by referring to the ICC rules, they are actually submitting also to the EPP, expedited procedure.
Then I would like to ask the experience under VIAC rules, Alice, is it really, do you also stay around 6 months for small cases? Does it really work in practice?
Well, first of all, I would like to say 2 issues. I mean, the majority of our cases are being concluded within 1 year, being complex or non-complex. The second of it is that we don't have a monetary threshold for the expedited, because we have completed the survey and we have asked our users, and I think the response was most of them would have been horrified if their claim would have been considered small claims when they fall under 2 million, because that is that's the usual sort of claims that we have from the cases in that region. And parties would have been horrified if their case would have automatically fallen into an expedited procedure, because it doesn't mean that the arbitrators have to be quick. They can do this. They are professionals, but it's mostly the parties and the councils who are not that sophisticated. It's their first arbitration. It's a very important case for them. And then to tell them, listen, your case is sort of small claim and you fall under 6 months and you only have like 4 weeks for submission of a statement. I mean, the response that we have received was, please don't do it, because you will completely overburden the parties, not the arbitrators. And then also we have a reverse system that when the arbitrators are very efficient, and we had cases that were not under the expedited rules, but regular cases that were completed by 3 months, the arbitrators get more. It's not that they are being punished because they conduct proceedings fast, but to the contrary, they get sort of a surplus to their fees because they actually help the parties to save time and costs. And in the majority of cases, it's not the arbitrator's fees that is the majority of the total cost of the arbitration, but it's very often the council's fees. So we really, again, came from a completely different angle, but being mindful of the region where we operate and knowing the parties and the councils and what they expect from an arbitration institution. And I think that's key. You really have to know the market, the region, and the expectation of the parties in order not to create a certain weird outcome. And concerning the rendering of the award, we have now changed in the 2021 rules revision, insofar as we say 3 months for rendering of the award in commercial cases and 6 months for the rendering of the award in investment cases. Mm-hmm. So that is sort of the limit. And before that, we didn't have a real threshold, but rather a self-binding mechanism, but we wanted to really go one up. And again, if arbitrators do not comply with it and there's no reason, their fees can be decreased.
I would like to ask ISTAC experience. I think we have heard 2 different positions. ISTAC is able to conduct the proceedings very efficiently, but without ending up with one arbitrator. Can we hear a little bit from Professor Akıncı how this expedited rules are handled under ISTAC rules and how it works in practice?
Sure. Well, first of all, if it is necessary, and for some cases it may be necessary, of course, even if it is a fast-track arbitration, it can be converted to a normal arbitration. And in one of our cases, we experienced this, and the parties, in fact, agreed to fast-track arbitration, but then it was an energy dispute with lots of technical expert opinion presented. And then it was going to be really very big pressure for the arbitrators and especially for the councils. And the arbitrator suggested that it should be converted to a normal arbitration. And then our board agreed to do so. And the parties were also very reasonable. And then it became a normal arbitration, not a fast-track arbitration. But having said this, I have to say that we had quite positive experience, especially for our domestic arbitration. At the beginning, when we had the target for 3 months fast-track arbitration period, many people said it is a not realistic time. But fortunately, maybe it depends on the parties' cooperation, not only the arbitrator or institute, of course. It worked very well. And we also experienced some of the very eminent colleagues from Turkey regularly had a fast-track arbitration in the contracts, although it wasn't a very small cases. And because when they drafted the contract, they agreed to a fast-track arbitration and they knew what they were doing. Again, it worked very well. But I fully agree with my colleagues, if the case and also the councils are not convenient for the case, of course, fast-track arbitration may not be a realistic option. However, for our especially domestic practice in ISTAC, I'm happy to say that so far it worked, and we had, I think, more than 30, something like this, percentage of our cases conducted as under fast-track arbitration rules of ISTAC.
And I think also you have quite a lot of experience with emergency arbitration at ISTAC, Professor Akıncı, right? Emergency arbitration also is an important topic.
That's right. In fact, that is one of the concepts that ISTAC introduced to Turkish law, because under Turkish law, the arbitrators had the authority to give interim measures, but we didn't have such a concept of emergency arbitration. And we also experienced emergency arbitration. And sometimes it was painful, because I remember one of the application was right before Christmas. And it was very difficult for me as a chairman, you need to appoint. So it was very difficult to appoint immediately an emergency arbitrator, but very kindly, we convinced one of the very eminent international arbitrator in London. And then it was a beautiful decision with very nice reasoning. So it is a little bit challenging for the institutes, I have to say, but yes, ISTAC offers emergency arbitrator service as well.
I should say that it's a shared experience, Professor Akıncı, that emergency arbitrator requests always land on weekend, holidays, or Christmas, or Eid. It's like, it's never on a normal weekday.
Like you're experiencing now, you know, before Christmas holidays, maybe it could increase these days after this talk.
Say that if I just may add something regarding back to the EPP expedited procedure, just to, because this also might come up as a question, the scrutiny is preserved for the EPP. So the expedited, the scrutiny was not waived. And again, this is maybe to avoid any weird outcome, as per Alice's statement. We need to make sure that whatever is rendered after 6 months is as solid and as enforceable, as scrutinized as a regular procedure.
Okay. There is another question on the place of arbitration for construction disputes. You know, maybe Professor Akıncı, based on his practice, maybe he's well positioned to answer this question. London, it is being said that London is very often chosen as place of arbitration, and the reasons for that. You know, do you have any insights of that? You know?
If I may, I mean, I have many very positive experience in continental Europe, especially for Turkish party, like France, Switzerland, Vienna. These kind of countries are where we feel very comfortable. Our law are very similar, etc. So normally, under normal circumstances, they say, I think a Turkish council would negotiate an arbitration place, something like this, you know, like France, Switzerland, Austria, these kind of countries, we would feel more familiar. But the reality is, the question is very correct. When there is a big project, very often international finance is involved, and very often the banks, international banks, also a part of the negotiation. And as they say, money talks. You know, when they say, okay, we are going to finance this project, but the applicable law should be most probably English law, and the place of arbitration will be London, and they may even direct the institute. And at the end of the day, you may have a limited power bargain power, even as a state body, because finance is very important. And, you know, most of the time people think arbitration is one of the midnight clauses. Okay, let's agree. But I mean, arbitration in London is special, sometimes more expensive, and you need to be very familiar with the rules. I mean, there are, don't get me wrong, excellent arbitrators in London, of course, especially in construction. But when you negotiate such clauses, you should know what to do, what to expect, etc. But my personal impression is most of the time it is the financial institute who lobby London and the arbitration institutes in London.
You mean the financiers? Financiers, they have a bargaining power on
absolutely
the case of arbitration. Anything you would like to add?
Can I add something? I also have the experience that, you know, when it comes to big construction, very often you have also FIDIC, you know, and yeah, then again, it is being felt that London and all that is, you know, is seen as one package, which these are habits that are very difficult to be broken, but there's no necessity whatsoever. But it's maybe they have a model clause and that has been used, and you know, and it goes like this.
Yeah. And maybe the UK law firms also, the councils, they are more comfortable. So it's sometimes it's other parameters than really the seat being really arbitration friendly. Because when you dig further, the UK courts have some interference. It's not as traditionally, historically favorable to arbitration as Switzerland or Paris or maybe Vienna. I mean, you know, it's not, yeah, so it's sometimes other parameters that come into play. And as Professor Akinci was saying, it's part of the bargain. You give the seat and you take something else in the deal, so.
Okay, I think we are coming to the end of our session. The takeaways, I think, in my opinion, the institutions, they work similarly, but nevertheless, they have some differences. It's absolutely necessary to be aware of them. You know, the arbitration clauses shouldn't be the midnight clauses. In reality, they are the most important, one of the most important clauses of many of them, but they are equally important as the substantive provisions. I hope we could contribute to the participants' knowledge and their experience, and you know, and I would like to thank our guests for their contributions. I have to say, this was more even better than I have anticipated, I have envisaged, and this is thanks to your experiences, your knowledge. Thank you very much, and I would like to thank Alice especially, because Alice is retiring from VIAC very soon. I think this is one of her last event. That's the last event. I have witnessed in my practice that she has substantially contributed. That's why I said VIAC, Alice, you know, because for me this is associated, and I have no doubt that her successors will continue in the same way. And thank you very much again for all your contributions. If I think if there's anything else you don't want to add, we could close the session. Meltem Hanım, anything else you would like to add?
Just thank you all our guests and participants, and I think we should do this again in 6 months. Maybe we'll convince Alice to join as a guest or a participant.
Of course.
But, thank you to all. Thank you Ceyda Hanım, to Daria, Ziya Bey, and Alice.
Thank you.
And
for your time just before the holiday season.
Yes.
Thank you for Akol for hosting us also. Akol,
yes, it was a great pleasure, and I'm sure this will be repeated.
Maybe in person in Istanbul.
Oh yeah, that would be so great. We had planned it, and it was really just before the pandemic hit, and we had all set, and what a nightmare.
TÜSİAD does have a nice conference room, so I'm sure you'd be welcome.
Perfect.
We'd be more happy.
Sure.
Thank you very much, then.
All the best.
Thank you.
Bye-bye.
Bye-bye.
Thank you to all the participants. Thank you.